What is involved in a financial agreement? If you've decided to get divorced, you may well be wondering what happens to those things you own together or any debts that you have. The first thing to do is make a list of everything you own jointly or individually, as well as all your joint or individual debts. You may need urgently to preserve your interest in some of the assets. For example, registering your interest in a property you don't own to ensure this is taken into consideration when the assets are split. The next thing is to see if you can amicably agree between yourselves how your assets and debts should be divided. Think about what you and your children need and be realistic. It's important that there's full disclosure of both of your financial positions. If you think it'll be difficult to request this, mediation may help. Alternatively, your solicitor can propose a voluntary exchange of your financial positions. This will usually be done in a document called a Form E. If you manage to reach an agreement that seems fair for you and your children, this can be sent to the court in a consent order. In most cases, you won't even need to go to court. If you cannot agree, however, you may have to start financial remedy court proceedings. This might be for a court order to do with your home or an order for pension provision. In this situation, a court will take control of your case and set strict deadlines as to when certain things need to happen. The family law company will guide you through the process to make sure that your financial agreement is worked out in a way that is fair for you and your children.